Well, good evening, everybody. I'm not sure who's aboard yet with us, but I'm about to jump on Facebook here and join everybody that way. I kind of did this backwards a little bit tonight. 7:01. I am a minute behind. Actually, I think I got up at 7 o'clock, so I should be good still. But if you could, I'm just waiting for my internet to come through. Oh, that's not what I'm looking for. That's why. In the wrong box. Sorry. Here we go. Everybody should be up here. Good evening, everyone. Okay. Just checking in on Facebook, making sure everybody is ready. So I'm going to give myself an extra minute or two. Can everybody see me? If you can, please log in through the Facebook. There we go. We got Tracy. Thank you, Tracy. I'm assuming Bianca is going to be in as well. And I'm just going to give it a minute or two here if you don't mind. I apologize before I correct the test. That way I know that everybody will be aboard with us here for the test. And I'll know that everybody's got the opportunity to get their test corrected as well. What an experience last week. I hope you enjoyed it. I definitely did. To do it right out of the Institute on the Constitution headquarters in Maryland. And I will probably be doing not next week's course, but the following week's course from there as well. Bianca, great to see you. Anybody else can check in for me. That way I know that we got you all. And I know there's a lot of folks that aren't in on Facebook that are just in through email, so I hope you're present as well. I am going to pray. I'm going to pray. And we're going to get started. Lord, we thank you for this evening, and I thank you for the blood of Christ. And Lord, I need your Spirit to teach, Father, what has been blood-bought, these documents, Father. I thank you for the grace of God to be upon us to accomplish, Father, what we set our hearts and our minds to do this evening, and that's to learn, to study, and understand our civic responsibilities in this nation, Father, as we owe you allegiance. Thank you, Father, for fulfilling a promise. Thank you, Lord, that we are educated and instructed, Father, and we are empowered, Lord, to make a difference in this nation, Father, that we may receive of your blessing, Father, and to do judgment to wicked doers in Jesus Christ. And I thank you, Father, the government is upon your shoulders, and that you do, Father, establish your throne, Lord, through your church in Jesus Christ. Amen. Amen. Okay, we're going to get started first with the test. And go back to Lecture 5, Test. I hope you all enjoyed the book, The Law. Fantastic book. Fantastic. As a matter of fact, if you could, if you wouldn't mind, just type me on Facebook. Let me know your thoughts on that, because that is a phenomenal book, isn't it? I just thought it was great. The preamble of the Constitution uses the phrases to secure the blessings of liberty to ourselves and to our posterity. The framers intended to show by these words that B, they intended the Constitution to be a permanent document. Number 2, the Federalist Papers were written by blank and signed as Publius. That was Alexander Hamilton, James Madison, and John Jay. So that's number C. So 2 is C. Number 3, in the ratification debates, the Constitution supporters called themselves the what? D, the Federalists. Number 4, the phrase, we the people, in the preamble indicated the founders understood governmental power was derived from B, the consent of the governed. What a noble concept, huh? And to think that is our government. That's what it says in the Constitution. Number 5, prior to 1915 and the adoption of the 17th Amendment, senators were chosen by each state legislature. It gave the states a very powerful check on federal encroachment of states' liberties, or we the people of the states. Number 6, the primary characteristics of a republic, are D, all of the above. The government is indirect through representatives. The rule of law is supreme, and all men are subject to it. The minority has rights, even the majority cannot violate. Number 7, the weakness of a democracy is that B, majority rule is absolute, and the tendency is towards a mobocracy. Great example of that is if you look through France and their many revolutions. Number 8, Article 1, Section 7 sets forth the legislative process, providing that revenue bills always originate, C, in the House. If it's the people's money, then the people need to determine where it's being spent, and the House reflects more perfectly than the Senate or the President the popular will of the people. The President vetoes, number 9, if the President vetoes a piece of legislation, his veto can be overridden by, this is important to know, D, a 2/3 majority in both House and Senate. Number 10, in Article 1, Section 8, the powers of Congress to tax and spend is limited to B, the payment for debts, common defense, and general welfare. On to true or false? I know, it's too simple. I completely understand. Very simple. True and false. Number 1, the Anti-Federalists could justly argue that the Constitution Convention overstepped its jurisdiction because it was only authorized by Congress to revise the Articles of Confederation. That is true. Number 2, the opponents of the Constitution claimed that without a Bill of Rights, the Constitution was a dangerous document. That is true as well. Number 3, the Anti-Federalists had an advantage in the ratification debates because the term Federalist was widely known at that time. That is false. Number 4, the Constitution places limits on each state's authority. That is true. Number 5, Article 1, Section 2 through 6 establishes that the procedures and discipline of each house are to be determined by the Oval Office. That, of course, is false. Number 6, Congress has the authority to abolish all federal courts except for the Supreme Court. That is true. Number 7, the term federalism simply means shared power between federal and state governments. That is true. The preamble of the Constitution, number 8, grants specific powers to the federal government. That is false. It doesn't identify any powers. Number 9, the Great Compromise, which created the bicameral Congress, was the suggestion of Roger Sherman. That is true. Number 10, the advantage of the bicameral Congress is that the popular majority is empowered to advance legislation. That is false. The founders did not want the mobocracy. They didn't want democracy. Indirect through representatives is the way that our country is set up, that our form of government is set up. Now, as we move into Lecture 6, this deals specifically with the overview of Articles 2 and 3. Last week was Article 1. We wanted to go through that and help people understand, okay, this is the most powerful branch of the government. That is the legislative power. And then all powers, all legislative authority is vested in that. So the judicial branch can't create law. The executive branch can't create law either. When we understood that, that was last week's segment. If you're not super familiar with it, again, you can select the link and please watch the class again. But we're on to Lecture 6 now. We're going to go to Deuteronomy chapter 17, 14 through 20. It's important that we tie the Bible and the biblical references into everything that we're talking about. That's the importance of this course that you will not get on any other Constitution course. We will tie this in there. I shouldn't say any other, but any that, unbeknownst to me, most people learning the Constitution don't learn these sort of things. When thou art come into the land which the Lord thy God giveth thee, and shalt possess it, and shalt dwell therein, and shalt say, I will set a king over me, like as all the nations that are about me. Now, we're giving a biblical example of the executive power, okay? Because this is an example of executive power. Thou shalt in any wise set him king over thee, whom the Lord thy God shall choose. One from among thy brethren shalt thou set king over thee. Thou mayest not set a stranger over thee. He needs to be a citizen, which is not thy brother, but he shall not multiply horses to himself. Horses, bureaucracy, horses, bureaucracy. Nor cause the people to return to Egypt. In other words, go back into the bondage that they came from. Don't return unto the form of government that we just threw off. Think about that for a minute. He shall henceforth return no more that way, neither shall he multiply wives to himself, that his heart turn not away. That's adultery. And custom was probably still is, where royalty would marry into different royalty of different countries. It was political manipulation. Neither shall he greatly multiply silver and gold, and it shall be, when he sitteth upon the throne of his kingdom, listen to this, that he shall write him a copy of his law in a book of out of that which is before the priests and the Levites. The executive branch is to write a copy of the book of the law. And it shall be with him, and he shall read it therein all the days of his life. So the executive branch is to write the law, number one. Number two, keep it on him and read it every day of his life, that he may learn to fear his God. That is the emphasis. To keep all the words of his law and these statutes, to do them. Don't just read them, don't just memorize them, do them. That his heart be not lifted up above his brethren, and that he turn not aside from the commandment, to the right hand or to the left, to the end that he may prolong his days in his kingdom, he and his children, in the midst of Israel. That's an example of a biblical executive. And that standard was followed, and we're gonna get into that, because Article 2 deals exactly with our president, Article 3 being the Supreme Court. But let's start with the president. Alexander Hamilton, the Federalist Paper number 70, I encourage you to read that because he emphasized the strength of a central government. At the same time, he tried to emphasize and give lip service to, I should say, the importance of limiting powers, but yet he still wanted that strong central government. He was one of the Federalists, one of the main authors of pushing this Constitution we've already studied. He was one of the main people that wanted the convention. Article 2, and I'm leaving that up to you to decide. What we have right now, is it better? What were Hamilton's thoughts, were they better? We need to determine that. We need to come at the conclusion with ourselves. I don't want to tell you and make up your mind for you. Article 2, the executive branch. This term, selection, qualification, and the succession of this executive branch. The convention voted for a 2-term limit, but George Washington voted against it. Originally, the president serves 4-year terms, but there was no limits. He could have served the rest of his life so long as he kept getting voted in. They originally wanted 2 terms, but Washington was against it. But then later on, so then they just accommodated him because they figured he would be the first president anyhow. But later on, a convention eliminated it, Washington served 2 terms and then announced that that was enough. So that set a tradition. It was never written in the Constitution, but no president served more than 2 terms up until FDR. Because out of respect and the tradition that Washington served, and then he said he announced that that was enough to serve for 2 terms, so it was kind of a tradition that was set. Look at the honor and the dignity that we had in our statesmen. Franklin Delano Roosevelt was elected for 4 terms, then he died in his 4th term in 1945. And then it was enacted of the 22nd Amendment, 1951, limiting the presidential term to 2 terms. I guess they figured, hey, we don't want another FDR in there for this long. Not a good thing. We need to limit that. So that's what happened. 22nd Amendment. Limited, finally. The Electoral College, this was altered by the 12th Amendment in 1804. Suggested reading is George Grant. Now, this is a book about the Electoral College. You can find it at theamericanview.com. There's a store there. They have a book about it. However, in your homework tonight, I'm going to be sending you notes where there's just a short, simple video that will help you understand the Electoral College, because it does take some, I'm going to scratch the surface tonight, but it takes some digging into, and I want you to be able to do that, because it's really a fascinating thing. This more directly reflects our republic and our Republican form of government. Each state's electors equal the total number of senators and congressmen from that state. So the state of North Dakota, South Dakota probably gets 3 votes, Wyoming, so on and so forth. So you take your state, that's how many electors you get in the Electoral College. Each state's electors normally are pledged to support the candidate who carried their state, but sometimes they violate that pledge. So if there's 7, let's just use 3. It's easier. There's 3 electoral college representatives in the state of Wyoming. And the popular vote, the majority of people vote in the state of Wyoming for, we'll use last presidential election, Mitt Romney. Now, those that are in the electoral college are selected by the state legislatures. State legislature chooses, so they determine 3 people in that state. Those 3 people then are supposed to vote for the person that carried their state. However, they don't have to. See, again, this is a republic, not a democracy. It does not have to support the majority. If no candidate receives a majority, then the race goes to Congress. So what happens is you get all these electors in the states to cast their vote. Now, once they've casted their vote, there's a majority has to be given. Now, the problem is if you have 3 parties, 4 parties, sometimes it's difficult for one person to get 51% of that vote if you've got it broke up into 3. So it does make it simpler to have a 2-party system in this means. I'm not saying it's good to have a 2-party system. Matter of fact, many of our founders spoke against that. But in this means, if the Electoral College can't come up with a conclusion or a majority to each delegate, then it would go to Congress. House chooses the president, each state casting 1 vote as majority of that state's congressman desire from the top 3 from the Electoral College. The Senate chooses the vice president, 1 vote per senator from the top 2 for the Electoral College. Of course, this is what's written in the Constitution, that portion has changed with the vice president and the presidency. Electoral College is a state check on federal power. It protects smaller states because these smaller states have an opportunity to still have a vote that counts even though their population is so small. Electoral College, with the 2-party system, 1 candidate almost always receives the majority in the Electoral College, and that's what we have nowadays. You have a Republican and Democrat. I think the closest independent that's ever happened for Ross Perot back in the 80s with Bush and I forget the other candidate. Was it Dukakis? I believe it was Dukakis. No, it was not Dukakis. I apologize. Maybe it was Clinton. Anyhow, presidential qualifications. This was a suggested viewing. Dr. Herb Titus has a video on theamericanview.com. There is a video just about this, being a natural-born citizen, why it's important for our executive to be that. Of course, the point is, and we just discussed it, or God commanded in the executive branch in the book of Deuteronomy, that we have an executive that is one that is born in your nation, your brother. Why? Because it's an issue of allegiance. If somebody's not born here, they don't share the same ideals, they don't have the same philosophy, they don't have the same religion, perhaps, that person is not going to care so much about the destruction of what happens in his own backyard. I mean, it's like having a renter in your house as compared to having you in your house. Who's going to take care of it better? Of course, the one who owns it. He's got skin in the game. This is his home. And that's the most important part right there. The president must be at least 35 years old, a resident of the United States for at least 14 years. So in other words, he could have been born here but then moved and lived abroad. But he needs to have lived here for at least 14 years. Succession is altered by the 22nd Amendment. In 1951, the 25th Amendment, this is the succession of the president if that president was to die. But originally it was the vice president succeeds the president and serves as acting president if the president is alive, but unable to fulfill duties of office. I believe that actually happened with Roosevelt. There was another president, but his wife kind of did the job for him, and I want to say that it was Woodrow Wilson, but I don't want to step out on that limb quite now, but sometimes presidents become incapacitated because of their health or what have you. If the vice president becomes vacant, then the president nominates vice president subject to confirmation by majority of both houses of Congress. So this is what happens if the vice president's plane goes down, if you will. If both houses become vacant, the Congress by law provides for succession. So if they both are in the same plane and it goes down. I don't mean to speak morbidly, I'm just trying to give an example. Congress has provided Presidential Succession Act of 1886. This has been amended numerous times. Look in your notebook, you can check it out. And honestly, I don't know why it's amended so many times. It's really not a difficult issue, but it has been. The order of succession shall be, number 1, if both president and vice president are taken out, then the Speaker of the House becomes the president. Or, if the Speaker of the House is taken out too, for some reason, the president pro tempore of the Senate. This is similar to the Speaker of the House in the Senate. or cabinet officers according to their seniority of their departments. Say all 4 of them are gone. Now we go to the cabinet officers, so it could be the Secretary of State, whomever, according to the seniority of their departments. Probably, actually, the Secretary of State. Compensation in the Constitution, it deals with compensation, Article 2. Also, the oath is dealt with. And this is to, quote, preserve, this is straight out of it, protect and defend the Constitution. That's part of the oath that they swear to uphold. Washington added, so help me God. That's actually not in the Constitution. But it started a tradition. Remember we talked about the tradition of the 2-term limit that Washington essentially started. Well, this tradition has been carried on for, well, ever since he swore his oath, so help me God. That's what men say when they put their hand on the Bible. And incidentally, Washington started this tradition of putting your hand on the Bible, and he wasn't required to. It's not in the Constitution that he does that, but it is said, it is speculated that he put his hand on Deuteronomy 28, which is the blessings and the curses that God defines for a nation that is either A, obedient to him, they receive his blessing, or disobedient, what those curses might be. So when he put his hand on there, he said, so help me God. This oath is an oath of a man being exalted with powers above his fellow man. Now, when you look at it through biblical context and through the actual context, you become a servant. The point is this particular, like Solomon said, how am I to lead this great people? I need your wisdom, Lord. And that's what Washington, I believe, felt when he prescribed that traditional oath, so help me God. And on Deuteronomy 28, he knew what the consequence would be if he failed to be a good ruler, if the people failed their duties before God. Section 2 deals with the powers and the duties of the president. The commander-in-chief of the Army and Navy, that is what the president is, he's an executive officer, and state militias when called into federal service, not until then. He has power over armed forces. His power over armed forces is actually shared with Congress, among Congress, president, and the states. So it's not like it's just his army. It's not like Napoleon's army or Caesar's army. There's a lot of checks and balances here, and we're going to dive into that. Congress makes basic rules for the armed forces. They have the military code that they determine. This is the rules. You know, this whole stupid don't ask, don't tell, and stuff like that. You see that argument was in Congress. Why? Because they developed the rules for the armed forces. President gives day-to-day orders and more specific regulations. He's the general, essentially. It's the easiest way to understand it. The states control the militias, except for when in federal service. That's part of the powers delegated by the states to the federal government once war is declared, when they're in federal service. The War Powers Resolution attempts to define this sharing of power, try to get a little bit more specific as to how do we share all of these powers. At what point does the president cross his boundaries? At what point does Congress have to back up and allow the president? That sort of thing. Now, this was the authorized use of American troops to help others. It's never been tested by the courts. Congress has made no declaration of war or overrode any vetoes. Here's the problem. Right now, with this War Powers Resolution, you have 60 days in. A president gets 60 days in. He can call and declare, we need to go to Afghanistan, we need to go to Syria. 60 days in there without getting approval from Congress. If at that point Congress has not approved it, then he must pull the troops out. He gets 30 days. So technically speaking, the president can make an executive call. For 90 days, he can put troops in harm's way. There's also another thing, too. Who authorizes the use of American troops for the help of others? Well, this is described in the War Powers Resolution. The problem is this War Powers Resolution has never been tried in any courts. Many people say, or speculate, that it's because each branch of government likes to be able to blame the other one. So Congress can say, well, there hasn't been a declared war since World War II. See the presidents, look at the Democrats or the Republicans, look what they do, look what they do. And then the president can point the finger back at the Congress and say, well, they sat with their hands on their, sitting on their hands. They weren't doing the right thing, so I had to step up and do it. They don't want to be checked. They don't want it to be defined. That's a speculation. And I could understand that just based upon the way that government now has kind of aligned itself together, and it seems like it's us and them. That's wrong. Instead of each person representing us and then fighting for our rights. This may require a written opinion of cabinet officials. No, such officials have 2 duties. This is about the duties of the president. Administer departments advise the president. This is their duty. This is the cabinet's duty. Okay? So you have cabinet, chiefs of staff, you have the secretary of state, etc. These are cabinet officials. Their job is to administer departments and advise the president. There's no such thing as a czar. That's a Russian term. It means supreme ruler. Czars are not in the Constitution. Look it up. You won't find it there. Again, it's a Russian term. It means supreme ruler. They may pardon offenses. Presidents may pardon offenses. All federal offenses. So this includes contempt, the exception of impeachment. Why? Because royalty in England used to allow the parliament to impeach somebody, but then they would just come by and pardon them. So all of this work, all of this time to convict a man, throw him out of office, and then all of a sudden the president can just come on and pardon that treasonous offense? No. Our founders did not go for that, and nor is it gone for in our Constitution. The English king used to frustrate Parliament, like I just explained, by pardoning impeached officers and restoring them to their positions. He may pardon before, during, or after the indictment or conviction. So let's just say that he's in the middle of court, they're in the middle of trying him. He can pardon him then. He can pardon him after the conviction. It's not time sensitive. This is a means of tempering justice with mercy. And it's an executive check upon the judicial branch. Say the judicial branch finds a man guilty, they can put a check on that man. Or they can put a check on the judicial branch. So here's the checks and the balances of each department. He may make treaties with the concurrence of 2/3 of the senators. The president can't just go out and make a treaty on his own. He needs 2/3 of a concurrence of Senate. The reason that the House concurrence was not required is because the framers thought this would jeopardize the executive secrecy necessary in negotiating treaties. That was John Jay in the Federalist Paper number 64. That was the reason for keeping them out of it. Understanding that, we move from the area of treaty the way that the Constitution prescribes it, and we move into court-created exceptions. Remember, all legislative authority is vested in this House, Congress. But court-created exceptions. So the court comes in and creates exceptions. Let's read about it. There's commercial treaties require only a majority of both houses. Not 2/3. 2/3 is a hard threshold. So we shouldn't be doing a whole lot. It should not be easy for government to do anything, except for to defend us and protect our rights. And here the court created an exemption. Examples of these are NAFTA and GATT. This is where we put people with foreign allegiance in authority over commerce in America. Think about that. Foreign allegiance in authority over commerce in America. See, it's kind of like the elephant. He gets his little trunk under there. Next thing you know, his head's under there and all of his feet. Next thing you know, he dominates. The court created exceptions. The executive agreements, here's another one. Executive agreements do not require concurrence of either branch. What in the world is an executive agreement? It's nowhere in the Constitution. But U.S. versus Belmont, if you look at that, in 1937, again, 1937, the New Deal, with Mr. Truman on the scene. We talked about how he obliterated the Constitution through the necessary and proper clause, also the general welfare clause, intrastate commerce. I mean, look at all these. All this is happening in the 30s. This is the Security and Prosperity Partnership is another example of this. Our president, I believe, was Bush W. Mexico, United States, and Canada, the American Union, New World Order. These are things the executives go out and create because the court gave the exception an executive agreement. Oh, we shook hands on it, we talked about it, and this is our agreement. See how dangerous this can be. It takes all the powers without any checks to it and puts it into that executive branch. Very, very dangerous. They can appoint Supreme Court justices, the presidents can, ambassadors, and major federal officers with the advice and consent of Senate majority. It's not just advice. They don't care about the advice. It's the consent. There has to be a vote of a Senate majority before they put in a Supreme Court justice or an ambassador. That's why you see when Elena Kagan comes, there's the questioning. Usually the opposite party is grilling this new candidate, etc. The president may appoint justices. He may authorize and appoint lower federal officers without the Senate's approval. Now, this is bureaucracy here. So something below an ambassador or a Supreme Court justice, just lower federal officers. And this is where you get the czars and you get a whole bunch of other things that just come in. That's where the bureaucracy builds, because the president can do this unchecked. Nobody has to agree. Nobody has to confirm. The president may appoint justices, ambassadors, and cabinet officials without Senate approval while Senate is in recess. We had an example of this not too long ago. They shall cease to hold office at the end of the Senate's next term if the Senate does not confirm them. So they don't have to vote them out. If they don't confirm them, they're done. Congressional check on executive power. This is a congressional check on executive power. So the president may come and say, I want this. Congress may say, sorry, bud, I'm not going to cooperate with you on that. The idea of checks and balances came from John Witherspoon. That's a very important thing to understand. Nobody can unilaterally make a decision that can affect us in the United States of America. They're not supposed to be. That's the way that the Constitution is established. I'm talking major decisions. This is the congressional check on that executive power. Now, the idea of this checks and balances came from John Witherspoon. And he was a preacher. He was a Puritan preacher. He was the president of the College of New Jersey, which is now Princeton University. He was a law school. And he was a Covenanter. He was a Scottish man. Some say he has ties back to William Wallace. Witherspoon taught no less than 9 of the delegates. Excuse me, not William Wallace. I want to say John Knox. I can't say either one of those definitively, so please don't hold me to it. But he's got some great history, I can tell you that. And he was a signer of the Declaration of Independence. He did not sign the Constitution. However, no less than 9 of the delegates to the Constitutional Convention, including James Madison and Luther Martin from Maryland, were his students. So he taught he taught this philosophy to his students. His students, of course, then brought it with them and embodied it or impregnated it into the Constitution today, these checks and balances. Witherspoon's major contribution to the founders of the federal government was the idea of checks and balances. It provides a way in which different branches can impede each other. In other words, slow each other down. And slow the actions of government. Again, we don't want government to be able to just go out and do stuff. For more information about this, there's a great book. It's called Christianity and the Constitution. It's right in your notebook. Chapter 6 by John Eismo. You can find the book, of course, at theamericanview.com. Now, on your next page, we have the powers and ceremonial duties of the presidency. This is to give information to the Congress. He can give a State of the Union address. We've all heard it. At least I encourage you to watch it. Even if it's going to kill you, watch it. It's important. It's a tradition with no legal force, but it helps set the tone for the country. Now, the State of the Union address this year was almost identical as the one that it was last time Obama gave one. So it's to set a tone. It's to pump people up. It's kind of a PR move. This is what we're going to do in America. This year we're going to have to da-da-da-da-da. And they get all the major news networks and everybody covers it and it goes out there. It's the front page of the papers. He can recommend legislation during the State of the Union, but someone in Congress must introduce it. The president cannot introduce legislation. So if we blame legislation, we can't blame the president. We can't blame the president for that legislation. Unless it comes across his desk, he has the opportunity to veto it, and he doesn't. Because he can't bring it forth. He may convene an emergency session of Congress. That could happen. So if they're on recess, he can convene an emergency session and say, hey, listen, there's a national calamity. We need to deal with this. He can receive foreign ambassadors. Hear about that quite a bit. He brings them into the White House and wines them and dines them. Faithfully execute all laws of the United States. That's his job. He's the executive branch. That's why the DOJ sits underneath. He is to administer, faithfully execute all the laws of the United States. He can commission all federal officers, and these federal officers have, with substantially, the same oath taken by the president to support the Constitution, so they have to swear an oath as well. Impeachment. A lot of people like to talk about this. I like to talk about this. This is important. This applies to the president, the vice president, and all civil officers, as expressed in the Constitution. The only grounds of impeachment, the only way somebody can be impeached isn't, well, I don't like him. I don't like the suit he wears. I don't like the color. I don't like what he's doing. I don't like he's a Democrat. I don't like he's a Republican. I don't like that he doesn't help the poor. None of that. He'll only be impeached because of treason. The word treason literally means levying war against the United States. This has to also be an action, not a thought. This is important to understand. We're going to cover that a little bit more when we talk more about the judicial branch. Because the founders understood privacy of thoughts. liberty of conscience, as we discussed, I think, in our lecture 1. Bribery. He can be impeached because of bribery. He can also be impeached for other high crimes and misdemeanors. Now, high crimes and misdemeanors, I want to clarify the meaning of this, okay? Because it's important. Some people think, well, you had to commit mass murder or something major. No, misdemeanors is not a major crime. High crimes and misdemeanors literally means real criminality, breaking a law. That's it. Our president should not be breaking any laws. Abuses of power, violation of public trust, as defined by Alexander Hamilton in the Federalist paper. This is how it was defined. When it was written, this is how it was defined. In 1970, Representative Gerald Ford defined impeachment offenses as, quote, whatever a majority of the House of Representatives considers it to be at a given moment in history. In the past, Congress has issued articles of impeachment for acts in 3 general categories. And that's what they were: treason, bribery, other high crimes, and misdemeanors. It's not whatever the House of Representatives deems it to be. But it is clearly defined in what the Constitution says. The procedures for the House votes to impeach, this is what they have to do. The House votes for it. They've got to start this. Then the Senate votes to remove from office. 2/3 are required. The Chief Justice presiding. So the House of Representatives comes forth, drafts articles of impeachment, vote on it, and say, yes, we are going to impeach Bill Clinton. We'll get to that in a second. Then at that point, the Senate kind of acts as the jury or the trial or the judge. They hear all the evidence. They go through everything. The Chief Justice is presiding over the top, just to give it the man of the legal cloth is there to preside over, to make sure the proceedings are going correctly, the evidence is shared the right way, etc., etc. Then the Senate will vote. If the Senate votes, and they vote less than 2/3 to carry through the impeachment, they become the executive branch in this particular case, then the president is not removed from office. He was impeached, but he was not removed. In order to be removed, 2/3 of the Senate have to concur with the evidence that the House of Representatives brings forth against the person being impeached, whether it be the president or any other civil officer. This was used only 2 times against a president, impeachment was. It was with Andrew Johnson in 1868. The Senate fell 1 vote short of removing him. It was a 35-19 vote. Therefore, he was never removed from office. He remained the president. William Jefferson Clinton in 1998 was impeached by the House. Again, you can be impeached and not removed. He was tried by the Senate and acquitted on February 12, 1999. For Article 1 of the impeachment, it was a 45-55 vote, and Article 2, 50-50, so it's right through the middle. So he was never impeached. Actually, he didn't even come close to becoming... He was impeached. I need to clarify that. He was impeached, but he was never removed from office. In 1974, Richard Nixon resigned as the House prepared articles of impeachment, so it probably would have happened there, but he resigned before it did happen. And think about that. Our president was removed without any bloodshed. He resigned. Just think about that. Most countries across the world, historically speaking, can't say that. It's been bloodshed. Not in America. We've never shed blood, excluding the War of Resistance, to throw off one of our leaders after we set up our own established government. This was used 11 other times against federal officials. This is impeachment. These included 9 judges, 1 senator, 1 cabinet official. The Senate acquitted all except for 4. All 4 that the Senate actually went through and voted 2/3 were judges. The senator was acquitted because the Senate ruled Congress lacked jurisdiction to impeach a senator. The proper remedy was expulsion. You can find that. They quoted the Constitution. Good for them. This is a legislative check upon the executive power. In other words, the president gets a little too carried away, the legislative branch can remove that man. This promotes stability by providing orderly means of removing officials without bloodshed. Very important. We need to consider that. We consider ourselves in America, we live in our own paradigm, but across the world you don't have that. You want to remove a leader, oftentimes there has to be a coup, a takeover. You saw what happened in Egypt. You just see these things happening geographically around our world. We don't have a clue about them other than to watch them. We've never experienced them. Article 3 now. We've done with the presidency here. If you have any questions, you can go ahead and type in, or any comments up on Facebook or instant message me. We're going to move to Article 3, the judicial branch. Yeah, okay. I want to give a quote for this treason. The idea of treason, we're going to get to that in a minute. I just can't forget that. Sandra Day O'Connor, one of our Supreme Court justices, I'm going to use this as an example. Treason is levying war versus the United States. Okay? This has to be an action, not in thought. It has to be something that we can tangibly say he is guilty of that. Not we think he is because of this. Sandra Day O'Connor, according to the Atlanta Daily, said, quote, I suspect that over time we will rely increasingly, or take notice at least increasingly, on international and foreign courts in examining domestic issues. Then she added, this doing so may not only enrich our own country's decisions, I think it may create that all important good impression. What in the world is she talking about? That's treasonous right there. She swore an oath to uphold the Constitution as a justice. As she swore that oath, she said, this is the law, this is what I'll abide by. Now what she's saying is we need to consult other nations' laws. Wouldn't that be treason? Sharia law. It's talked about quite a bit in this day and age. Some courts would even arrange their proceedings around Sharia law. That's treasonous. That is a foreign system of law being brought into America. It's like bringing foreign troops into America and say, tell us what you would do. She's, of course, was not removed for that comment, but I just wanted to highlight that that comment was made. And it's important to understand, treason, she gave lip service to it. She embraced it. I think it creates that all-important good impression, she said. The judicial power is vested. That means it permanently resides and it cannot be divested from the judicial branch, the Supreme Court. The lower courts are as Congress determines, so Congress can choose lower courts, appoint them to different states, etc., different districts, and Congress can also do away with those. Congress has not done that for, well, I think well over 100 years, but Congress has established federal district courts and circuit courts of appeals. Congress could abolish them. Judges hold office, quote, during good behavior. Now, some people say judges are just, they're in office until they die. It's a lifetime, I almost said sentence. It's a lifetime appointment. That is not true. It says they hold office during good behavior. Well, what would be bad behavior? We'll talk about that in a second. But the reason that Gouverneur Morris said this, those who are charged with the important duties of administering justice, listen to this, and think of the philosophical worldview of our founders at that particular time. Think about what law they understood, what law was, who was the author of law. They understood the fear of God. They understood the future rewards and punishments that they would give. They understood when they swore an oath, it was before God. They were accountable to God on how they served the people. So for him to make this statement, he was from Pennsylvania. He was actually the one who penned it. He wrote part of the Constitution. Those who are charged with the important duties of administering justice should, if possible, depend only on God. In other words, they shouldn't have to go out and campaign. They shouldn't have to be under anybody's approval but God's first. Important. Why is that so important? Well, think about it. In that day and age, it was important because of what the worldview was of the people, what the standard was, what people understood, what were the presuppositions of all of this, of government and why we started this. Apply that now in this day and age, and what do you got? Well, we don't even claim as a government God's authority. Well, sporadically here and there we do, but I'm saying as a whole. So if we left it up to them and quote-unquote God, the God that they determine or don't want to determine, is there any security for our rights? No, we have to step it up even another level. That, of course, goes back to the church's duty in society. They need to be salt and light, not this worthless salt that needs to be cast into the dunghill, as Christ said. It's worthless. If it can't be salted, then you toss it in the sewer. It's worthless. Good behavior, speaking of judges hold office during good behavior, means fidelity to the Constitution and positive moral examples. There have been judges that have been impeached because of drunkenness, public drunkenness, good behavior. That's expected. You think about that. If you're a judge, well, he's just a man. What he does in private is his own. No, what he does in private reflects what he'll do on the bench because that's his moral character. He doesn't all of a sudden just switch into a different person because he's got the gavel in his hand. I have a video as well of Sandra Day O'Connor. So I'm going to be sending some of these things out in your homework or in the email that follows up with the webcast here. Compensation may not be diminished during their tenure. This prevents congressional interference with their duties. So if all of a sudden Congress decides, hey, listen, we're kind of ticked off at the judicial branch, they're not giving us our way, we're going to vote them a pay decrease. That's kind of a get-even tactic. It's not a check or a balance. So therefore, they can't have their compensation reduced during their tenure. The proper role would be for Congress to impeach them if they feel they need to be removed. Jurisdiction of the courts. All cases in law, that's statute, and equity, these are the general principles of fairness, equity, equality, arising under the Constitution, federal laws, or treaties. In Marbury v. Madison, Chief Justice John Marshall interpreted this language to authorize judicial review. Poor decision. I believe it was a poor decision. Thomas Jefferson agreed. Judicial review. So in other words, they look at a statute and say, is it even constitutional? What is that doing? Well, that's assuming a power that belongs in the legislative. Remember, all legislative power is vested in Congress. It's assuming a responsibility and a role that legislative, statutory law can be determined by the Supreme Court. They can also, in cases of law, they involve foreign officials, so the Supreme Court judges foreign officials. Involving admiralty or maritime law, this is obviously, it's on the water, so it's outside of any particular state's jurisdiction. Involving controversies between two states, this is what the Supreme Court, this is what they try. Involving diversity of citizenship, this is a citizen of a different state or a foreign nation. Involving suits between a state and citizen of another state or nation. This, of course, was changed by the 11th Amendment in 1795. I think it was the state of Georgia decided it didn't want to be sued. So that amendment was changed, like say, through the 11th Amendment. The types of jurisdiction. There's the original jurisdiction, which is a narrow range of cases involving foreign officials and states as parties. Okay, that was all the Supreme Court was trying. The appellate, or all other cases, with the exceptions as Congress shall make. So if Congress determines, the appellate jurisdiction would take that over. This is an important check on judicial power. Congress can limit the court's appellate jurisdiction. And that was what we were talking about, right? Nope, they can even set these courts up and they can take them down. Congress has not used this check for over 100 years. In other words, Congress could say, no, that jurisdiction in that appellate court cannot be seen by that court. They're not going to make a determination. We have set it, therefore that's what it is. It's the law of the land. Types of cases where Congress could limit the court's appellate jurisdiction. I want to give an example where we could limit this appellate jurisdiction. The Constitutional Restoration Act, and I believe that's also part of the homework today to read that through, or at least it was in the last segment, but let's continue. Notwithstanding any other provision of this chapter, the Supreme Court shall not have jurisdiction. Listen to that. Congress is telling the Supreme Court, you will not have jurisdiction to review by appeal, writ of certiorari, or otherwise, I hope I didn't mispronounce that name, I apologize, any matter to the extent that relief is sought against an entity, a federal, state, or local government, or against an officer or agent of the federal, state, or local government. They're telling the Supreme Court, listen, you have jurisdiction, but here's where you don't have any jurisdiction. Let's keep going. Whether or not acting in official or personal capacity. Concerning that entity's officers or agents, acknowledgement of God as the sovereign source of law, liberty, or government. What is Chief Justice Roy Moore actually brought this forth? And some senators attempted to bring this forward. It was called the Constitutional Restoration Act. Obviously, the federal government is breathing down its neck to remove his monument. If you don't understand the case, please Google search it, Chief Justice Roy Moore. And what he was saying at that particular time, the Supreme Court has no jurisdiction over cases where the acknowledgement of God as the sovereign source of law, liberty, or government is brought up. So all these prayer cases, all of these nativity, all of these things, the Supreme Court could not make any determination. Don't get me wrong, the state courts still could, but it would take it out of the federal jurisdiction. And this could be an act of Congress gone forth from our Congress to pass to say, Supreme Court, you have no business over here. No more Supreme Court rulings on can we have, baby Jesus on the City Hall steps, or can we say Merry Christmas or anything like that. Gone, out of their jurisdiction. Congress could do that. Maybe somebody watching right now should run for Congress. Now we close by talking about treason. The definition, treason, this is literally the definition. Treason against the United States shall consist only in levying war. In other words, not thought, well, I just have a feeling that he hates America. So you have to levy war against them or in adhering to their enemies, giving them aid and comfort. That's pretty basic, pretty simple understanding. Now, the reason why we have this concept of treason. In England, one could be convicted of having treasonous thoughts. In America, Puritans taught that conscience was beyond the government's jurisdiction, so treason had to include acts. We talked about before, the police officer can't arrest you because you're thinking about breaking into that jewelry store and stealing that ring. But the minute your hammer hits the glass, you have the police officer now has jurisdiction because you've created an action. No plural reference to the United States. Notice this too. Treason against the United States shall consist only in levying war against them. Notice them. What does that mean, them? You mean against it? There's no plural reference to the United States as them and their. Not it or its. The framers thought of the United States as a union. So in other words, if we were going to say the United States, I'm going to ask you this question. The United States is going to war, or the United States are going to war? What would you think the best way to say that? Well, most people would say the United States is going to war. Well, no, that's not true. The United States, in other words, the states united as they come together, are going to war. It just gives you another example of how our framers intended. What was the original intent? What was the federalism? Right? We the people of the states, etc., things we talked about last time. Congress fixes the penalty for treason by statute, but may not include the corruption of blood. That is, citizenship or inheritance rights of one's family should not be affected by one's conviction of treason. That's a biblical concept. I can't suffer the penalty of my father breaking a law. That does not fall back down on me. So this evidence for conviction was two witnesses or a confession. You can go to Deuteronomy 17:6. These things are all biblical concepts put right into our Constitution again. So we've covered Article 2 and Article 3 of the Constitution. Next week we'll be discussing Articles 4, 5, 6, and 7, the rest of the Constitution. And we'll be discussing that at length. There's more to know, but right now we've covered the three branches of government. The first article is Congress, second article is the President, third article is Supreme Court. And how all three of those branches, what their delegated duties are, or what their, duties, I guess you could say, or their powers, and where their limits were too, how the different branches could limit each other in those. So I trust that all of you have got a whole bunch to think on here tonight. You're going to want to go through the review for the class tonight, and then of course take the test. So I encourage you to do both of those. And if anybody has any questions, as I always say, through the middle of the week, whenever you can think of them, you go ahead and give me an email, or you text message, or excuse me, not text message me, or you can Facebook me as well, because I want to make sure that everybody's grasping these concepts. And the other thing is, too, is as we're getting close, we're more than 50% done now. Next week is Lecture 7. We're going to start thinking about graduation and things like that. Now, next week is going to be another tricky week for me. Today, obviously, I thank every single one of you for being aboard with us on Tuesday. Next week could be a tricky week because we're going to be doing events all week. I may need to, so if you could stay tuned to your emails, I may need to shift that day, but I will always provide a video, And I may not even be able to do class next week, but I will double up on the following week. Just so everybody knows, we'll go through 2 sections the following week. But stay tuned for that, please. I will get back in touch with every single one of you. I appreciate you. Thank you for your graciousness, and I hope you have a wonderful evening. And Lord, I thank you in Jesus' name for heaven to bless, Father, your teachings, Lord, and that we can see your hand intricately woven through this form of government which we are studying now. Thank you for your revelation. Thank you for empowering us. Thank you for quickening us. Thank you that it sticks, Lord, and this seed produces fruit in Jesus Christ. Amen. Thank you so much, everybody. Does anybody have any questions? If you do, feel free, please, to email me here. I'll give it another probably 60 seconds or so. If not, please make sure that you cover your homework assignments. And that should be everything. Okay, I'm going to tune out of the webcast world, but I'll still be on Facebook. So if any of you have questions, please do send them over through Facebook. God bless you all. Have a great night.